Hello and welcome back to the Blackstone Solicitors YouTube channel, your go-to place for clear, practical legal advice. Today we're talking about something that trips a lot of people up. Registering a power of attorney with a bank. Now, this might sound like a straightforward admin task, but there are a few important steps you need to get right to avoid delays, confusion, or worse, frozen accounts. So let's walk you through it. But here's the key thing: you can't just show up at the bank and expect them to hand everything over. You'll need to go through a process to register the LPA with each financial institution the donor, that's the person who made the LPA, uses. Alright, let's break down the process. 1. Check the LPA is registered with the Office of the Public Guardian or OPG. Before you can register an LPA with any bank, it must be officially registered with the Office of the Public Guardian. If it's not, the bank won't accept it. You'll know it's registered if you see a validation stamp and reference number on the first page. 2. Gather identification. The bank will need to verify who you are. Expect to be asked for the original or a certified copy of the registered LPA, valid ID for you as the attorney, usually a passport or driving license, and proof of address, like a recent utility bill or bank statement. Some banks may also want ID for the donor, depending on the circumstances. Step 3. Make an appointment. While some banks might allow walk-ins, many will require you to book an appointment, especially if you're dealing with more complex lasting powers of attorney, or if there are multiple attorneys involved. Here's a top tip. It's a good idea to call ahead and ask what documents you'll need. Each bank has its own policy, so it's always best to come prepared. Now, on to step 4. Decide how the attorneys will act. If there's more than one attorney, the bank will need to know if you're acting either jointly, meaning all attorneys must act together, or jointly and severally, where any one attorney can act independently. The bank needs this information to set up access and permissions properly. If it's joint only, you'll all need to be present or provide signatures. And finally, step 5. Access is granted. Once the lasting power of attorney is approved and verified, the bank will set up access for you. Depending on the bank, attorneys may be issued with debit cards, be able to access online banking, and receive statements along with account information. Remember, attorneys have a legal duty to act in the donor's best interests at all times. Misuse can lead to serious legal consequences. Common pitfalls to avoid. Now let's talk about what not to do. 1. Don't assume all banks handle LPAs the same way. 2. Don't try to use an unregistered or incomplete LPA. 3. Don't forget to notify the bank if the donor loses capacity or passes away. And 4. Don't forget to keep clear records of all transactions. If things get complicated or you're unsure, it's worth speaking to a solicitor like us. At Blackstone Solicitors, we've helped countless families with setting up and using LPAs, including getting them recognized by banks, building societies, and other financial institutions. Thanks for watching. If you found this video helpful, don't forget to like, subscribe, and hit that bell icon so you never miss a legal update from us at Blackstone Solicitors. And of course, if you need personalized support, we're only a phone call away.